Mr. Davey.
May it please your lordship, may it please your ladyship. I appear on behalf of the applicant in this matter, His Majesty's Revenue and Customs, along with my learned friend, Miss Belgrano, my learned friend, Mr. Peacock, and Mr. Hellier appear on behalf of the respondents, Altrad Services Ltd, formerly known as Cape Industrial Services Ltd, and Robert Wiseman and Sons Ltd. The court should, I hope, have the following items: a core bundle, a supplementary bundle.
I should say we both read fairly extensively, and given the time constraints, I don't think you need to spend too long on introductory matters.
I'm grateful. The matter before the court is the Revenue's application for permission to appeal, or to be precise, part of the application for permission to appeal. This court already having granted permission in part in December of last year. My overarching submission is that permission should be given, and in making good that submission, I'd like to take matters in two stages. First, setting the scene and providing some context to run through the proceedings to date insofar as relevant to this morning's application. Secondly, deal with 2 or 3 specific points in relation to Section 11 arising out of this court's order of December of last year and my learned friend's skeleton argument or earlier submissions. The first of those will take a bit of time. I hope if I've done the work there, the second should be really quite quick. Moving straight to the first of those. It's been said in this court and the Supreme Court on a number of occasions that taxing statutes generally draw their lifeblood from real-world transactions with real-world economic effects. Lord Justice Carnworth in BMBF, approved by the Supreme Court in UBS, and quoted in the FTT's decision, paragraphs 206 and 251 in this case. It's not a new sentiment. Over 40 years ago, in the case of Ramsey, Lord Wilberforce referred to tax operating in the real world, not that of make-believe, page 459 of the Ramsey case. And your lordship and your ladyship, I think, will be very familiar that if it's possible to distill 40 years of jurisprudence down to a single sentence, then the aim is to do what is sometimes called the Ramsey approach of asking the ultimate question, which is whether the relevant statutory provision construed purposively is intended to apply to the transaction viewed realistically. The Hong Kong case of Arrowtown, approved in subsequent case law and referred to in these cases. Now, the reason I've referred to those very well-known dicta straight away is because in this case, although the FTT and the UT in the end landed in different places as regards the outcome of the appeal, they spoke with one voice as regards the fundamental nature of the arrangements. What they said very much had that real-world sentiment in mind, and what they said was not intended to be complimentary. The FTT spoke of sale proceeds simply going in a loop purely designed to enable the appellants to claim capital allowances without suffering any economic cost. FTT's decision, paragraph 260(2)(c). And that language echoes the Supreme Court's language in a case called Tower, where Lord Walker spoke of money in a case involving this very section, Section 11, going in a loop in order to enable the appellants to indulge in a tax avoidance scheme. Lord Walker, paragraph 75, Tower. And in the UT in this case, the arrangements were described as an artificial series of transactions which, on the unchallenged findings of the FTT, I'll repeat that, unchallenged findings of the FTT, were devoid of business purpose and affected only to achieve a magical increase in qualifying expenditure. UT's decision, para 96. And perhaps with some degree of understatement, the UT went on to say that some readers may therefore find their ultimate decision surprising. Now, faced with looped money, magical arrangements, unchallenged findings from the FTT's decision regarding arrangements devoid of business purpose, and having not got permission from the Upper Tribunal, the Revenue come before this court to ask for permission. And the nub of the Revenue's ground is expressed at para 2 of the grounds of appeal, which we can turn to if it's helpful, but I'll read out what it says. Okay, core bundle, tab 1, page 14. The ground on which the Revenue seeks to appeal is that The UT erred in law in holding that the requirements of Section 61, disposal events, Section 11, general conditions as to availability, plant and machinery allowances, of the Capital Allowances Act 2001 were met in the present case. And then in the sub-paragraphs that follow, we flesh out what we mean there. Section 61, paragraph 2.1, Section 11, paragraph 2.2. Permissions granted on the first already, so we're now dealing with the second. And the revenues focus on those two provisions, 11 and 61. Their pairing, as it were, is no accident. They are linchpins within the statutory scheme. Fulfilling their requirements is a necessary condition of being entitled to allowances, which the scheme in play here seeks to access. Accordingly, fulfilling those requirements is a necessary condition of the taxpayers succeeding on their appeals. The fact that these two sections play a key load-bearing role is not my submission, it's my learned friends. Could we go to the Upper Tribunal decision, please, at paragraph 6? That's Core Bundle, tab 4, page 45. Paragraph 6 is at page 46, and I'd be grateful if the court would read paragraph 6. I think so. I'm going at a reasonable lick. If I'm going too fast...
This is the bookend point, is it?
It's the bookend point. If I'm going too fast, no doubt the court will tell me. So, a couple of immediate points to note. First, the Upper Tribunal there is reciting pretty much verbatim the wording of Section 11.4, which sets out what is called the general rule. If your lordships want to see it, and they may not do, but if they want to, it's at the back of this decision, and one can find it in the appendix, page 70. But it's quoting it essentially verbatim. 11.4a says the general rule is that expenditure is qualifying expenditure if it's capital expenditure on the provision of plant or machinery, wholly or partly for the purposes of the qualifying activity. And it goes on from there. So that's what it says, and those two requirements of 11.4a, on the provision of and wholly or partly for the purposes of, are what are focused on in the ground that we seek permission for today. Second point to note in relation to paragraph 6, which my Lady Justice Whipple already have, there's the reference there to the bookends point, namely that one has to have both in order to get home. And the bookends reference is my learned friend's way of reflecting the fact that 11 and 61 play a pivotal role. If one trawls through the transcripts, one actually finds some half a dozen or so instances in which it's the appellant company's submission, or the way it's put is to look at them together and talk of them in terms of bookends. I can read out 6 or 7 transcript references.
I wouldn't bother.
So, key point, taking stock, what I want to say at this stage is, prima facie at least, the section in relation to which the revenue seeks permission is not tangential, but plays an important role within the statutory scheme, which the appellants must fall within and fulfil if they're going to succeed. It's a necessary condition for them to get home. Now, the reason I want to say that straight away is because I want to shoot down the idea, which I understand is being advanced on the other side, that they didn't realise Section 11 was an issue, and had they realised, they would have done things differently, or might have done things differently below. That's paras 7.2 and 8.2, their latest skeleton argument. I say that holds no water, and I want to make that good now. I'm going to do that by going through a number of points in relation to the FTT proceedings. It's a little bit stodgy, but I think it's important because it lays the groundwork, and I say is the answer on this application. Now, in a short permission hearing, where one has tribunal decisions of over 500 paragraphs and 800 pages of transcript, there's a limit to what one can do. But I do say pretty quickly we can see Section 11 was absolutely in point, and the taxpayer companies knew that it was. So first of all, I'm dealing with the FTT proceedings, and I have 4 points that I want to make. There's a little bit of moving between bundles if the court wants to go there, but just for that. First, Section 11 is expressly put in issue in the appellant's own original grounds of appeal. Supplemental Bundle 1, Tab 1, page 15. It says this.
Sorry, just, yeah, can I get that out? So
Yeah, sure.
Supplemental 1.
Supplemental Bundle 1, Tab 1, page 15. Hopefully the court has a page which a third of the way down says the appellant's position.
Yes.
So paragraph 12 there says, the appellant contends that its claim for capital allowances should be allowed on the following basis. And then a number of points are made, and if one looks at H, the payment for reacquiring the assets under the put option was qualifying expenditure under Section 11 of the Capital Allowances Act and gave rise to a new capital allowances claim. So it's expressly one of the building blocks that the appellant posit as a basis for the appeal succeeding. That's my first point. Second point, having considered those grounds, the revenue made clear expressly in their pleading that they did not agree with it. And on the contrary, they took issue with it. That is Core Bundle, Tab 12, page 206. So, if we're on the same page, it should be a page which has at the top the revenues case and just below that substance and reality. And what we can see there is that it is said that on the authority of BNBF, SPI, Arrowtown, Carreras, Tower, UBS and others, so a whole host of Supreme Court and other higher court cases, it is necessary to consider the facts realistically, whereas here the arrangements are planned in such a way that a number of agreements are intended to and do operate together, then one must consider all the steps taken in the scheme as a commercial whole. And it goes on from there. And what we see is that on the facts as the revenue currently understands, and the revenue will argue that on a realistic view of the facts taken as a whole, the original owner of the plant and machinery never ceased to own the plant and machinery within the meaning of the Act, and therefore there was, and it runs through a number of points, and if one gets to D in that list, no incurring of expenditure on the plant and machinery qualifying for further capital allowances under Section 11.
But might that not be said to be against you, as I think Mr. Peacock does say, because it starts off saying never cease to own and therefore. So when you come to your little d, that's coloured by the reason being never cease to own, which is a different point from the point you're now running in ground 2 of your grounds of appeal.
I see the point, my lord. I say it's a bad point. I don't shy away from the fact that the submission being put is a joined up submission. I don't shy away from the fact that if we get home on Section 61, then one doesn't need to do the rest. But the idea that one reads this as a concession, that if one doesn't get home on Section 61, we don't want to argue about Section 11, is a quirky way to read this. The revenue was not saying that. It was making a joined up submission. It's true Section 61 is a necessary condition, but the point is this, and this is really, I suppose, in a tweet, this is the crux of my submission. It is a necessary condition. It is not a sufficient condition. It is not a sufficient condition for the appellant to get home. And the revenue has never said it's a sufficient condition. They have to get through Section 11 as well.
What the Section 61 point is?
Yeah, it's a necessary condition for the appellant to succeed on, but it's not a sufficient condition.
But the role of your statement of case is to take what the taxpayer has said so far, set out your position, so you end up, as pleadings do, with issues. And you're not here saying anything like what you're saying in ground 2 of the grounds of appeal. You're identifying as an issue whether the taxpayers never ceased to own.
Well, we're setting out that one has to view the scheme as a composite whole, and we're saying that if one does that, then the appellants do not succeed on their appeal, And we're setting out why we say that is the case, including that they don't come within Section 11. I repeat, I don't shy away from the fact that Section 61 is a key point here. But it's not a sound reading of the revenues case, either in this document or throughout these proceedings. And it's also not a sound reading of the FTT's decision, which we'll come on to say that Section 11 was never an issue. It would be very peculiar if the game was Section 61 is what we're talking about, and we're not interested in anything else. Section 11 is a necessary condition for the appellant to succeed on. So I don't shy away from the fact that Section 61 plays a key role here. And yes, this is expressed as things that follow from the Section 61 analysis. But that's not all that it's doing. Two particular points. It's certainly not, as it were, a concession that we don't want to talk about Section 11. And also, one has to appreciate that this isn't a footnote or something. This is the very centrepiece of the case. It's the beginning of the case. It's substance and reality. It's made within the entire genre of recognising that one doesn't do things in a piecemeal fashion ever since Lord Wilberforce said what he said in 1980. So I do say that has to be read in that way. I'd also say that there's no responsive statement of case from the appellant taxpayers in this. There are skeletons, and if one goes to the revenue skeleton, which I'd like to if I may, this point is expanded on slightly. Could we go to supplemental bundle 1, tab 3, page 97. Page 98, in fact, actually. Sorry, page 97. So this is within the skeleton that was put in ahead of the hearing, and at paragraph 53, you will see a good deal of the text that I've just shown you in the statement of case repeated. But one does also see these words following on. So 4 lines up from the bottom. On this basis, the payment of the put option price was not expenditure on the provision of plant or machinery for the purposes of a qualifying activity within the meaning of section 11.4a. It was rather money put into a loop for the purposes of a tax avoidance scheme, by analogy with ensign and tower. So this is an absolutely orthodox revenue contention in relation to what they say is a tax avoidance scheme, that one has to look at the arrangements as a whole, stand back, along with what the Supreme Court tells us in Tower, and say, what's going on here? And so that's what we say there in relation to section 11. We say there wasn't expenditure incurred for the purposes of a qualifying activity. So, we've got a ground of appeal which refers to section 11. We've got a statement of case and a responsive skeleton which I say does engage with section 11, albeit section 61 playing a prominent role. What then happens when we get to the FTT? So I'm coming on to my third point. Well,
are you going to Mr. Peacock's skeleton for the FTT?
I am not going to Mr. Peacock's skeleton for the FTT.
Can I just see whether that might be relevant?
Yep.
Probably betraying the fact that I haven't grasped something, but if you go to the tab 2 in that bundle, we get the skeleton. And if we go through to page 54, we see that in paragraph 15, there's reference to the legal and commercial results of the
Sorry, which
sale.
paragraph?
Sorry, paragraph 15. Should be supplemental 1, tab 1, page 54. My bundle, anyway.
Thank you, yes.
So in the context at any rate of transaction 1, we get paragraph 15, the legal and commercial results of the sale were that. And then at 3, the taxpayers paid the consideration, so on and so forth. And in A and B, we get assertions that there were real commercial benefits. then also perhaps if we go on to paragraph 138 onwards, where you get a bit saying section 11 turns on the reason for payment, not the transaction. There's reference to time and cashback in paragraph 138, and on these facts that test is met. The taxpayers spent their money on assets they needed for use in their trade unless they spent their money they would not own the assets, and so on. And then 141, whatever HMRC assert was the purpose is irrelevant. What is relevant is at the end of the lease is the taxpayers no longer had access to the assets they required. By paying the amount they received the assets such that the purpose of the expenditure is plainly the acquisition of those assets. Now, at least to me, this seems closer to your ground 11, to your new ground of appeal. You're looking at the purpose of things.
Indeed, my lord. I said a few moments ago there was a limit to what one could do in the time, and a longer journey would certainly include reference to those documents, sorry, those paragraphs within that skeleton. What I'm trying to do is build up a picture which shows that it's just not the case that Section 11 was never part of this appeal.
But it's like looking at it slightly differently. The core question in the end is, will the taxpayers be prejudiced if you're allowed to run your new ground of appeal?
Yes.
And Mr. Peacock says, well, we'd be prejudiced because we would have been likely to put in evidence as to our purposes. And an element in that inquiry might be thought to be, well, did they think that they were dealing with purposes when they came to the FTT? And at the moment, I'm inclined to think that these paragraphs might suggest that they did think they were dealing with purposes when they went before the FTT.
Indeed, my lord. I would agree with all of that, and it's very much, well, what we've just gone to is a facet of the picture that I want to build up. I mean, the short answer to the question, are they prejudiced, is no, but I obviously need to show you why I say the answer is no, but that is one building block in that submission.
Yeah.
So we've looked at the grounds of appeal, we've looked at the revenue statement of case, we've now looked at the two skeleton arguments. What then happens when one gets to the FTT? Well, what I want to say now, so this is the third of my 4 points, is that one thing that that the tribunal had was the full suite of contemporaneous documentary evidence. It was in the bundle before the FTT, and it was referred to by the FTT. I want to list out, if I may, 7 classes of document, and I'm going to give references for the Cape Altrad transaction, but one could do exactly the same with the Wiseman transaction. And the reason I'm doing this is to show that there were factual findings in relation to the relevant events. The court may wish to have the FTT's decision to hand, but equally it may be that I can take it reasonably shortly.
Yeah.
So I said there were 7 items, 7 classes. Number 1, there were tax planning documents. One sees reference to that at the first tier tribunal's decision at paragraph 38, including KPMG writing in June 2010 under a paper entitled Short-Term Financing, setting out the steps in the transaction and a summary of the tax benefits, risks and costs. So number 1, there were tax planning documents, FTT 38. Number 2, there were minutes of meetings of the directors of the companies resolving to enter into and carry out the transactions in question, FTT para 43 and FTT para 50. Number 3, there were the relevant contracts, sale and purchase agreement, lease, put option, call option, parent guarantee, FTT para 44. Number 4, there were letters regarding fees and payments, FTT para 45 and 47. Number 5, there was a valuation report, FTT para 44 sub 9. Number 6, there were delivery and acceptance certificates in respect of assets, FTT para 52. Number 7, there was accounting-related correspondence from PwC, FTT para 53. So the contemporaneous scheme-related documentation was in the bundles before the FTT and referred to by the FTT in the decision. And as I say, a similar exercise was done by the FTT in relation to the Wiseman transactions, that's paras 54 to 69. It's also worth noting, and this may chime with your Lordship's observations in relation to the appellant taxpayer skeleton argument, that at paragraph 70 of the FTT decision, this is still within an overarching facts section. There is a heading, commercial purpose, which records a submission by my learned friend on purpose and the revenue's response.
And just in that context, one of the things they make is, one of the points they make is a point about estimated interest rates. And there, picking up, I think, what Mr. Peacock had said in his skeleton, you do find in the supplemental bundle, tab 6, your response on the cost of funding, where you say you do not accept that there was any commercial benefit.
Indeed. And then if we go to, still within this section, paragraph 75, so this is within the commercial purpose section itself, within the fact section, we have at 75 the FTT making a finding based on what it calls the design and economics of the scheme. This is the final paragraph within this section. It may already be familiar to the court, but if not, I'd ask that the court read paragraph 75 or remind themselves of it.
Yeah.
So the tribunal has gone through the full suite of documents relevant to the transactions. It's now stepped back and taken stock, and it's made a finding as to the rationale for the arrangements based on what it calls the design and economics of the scheme, and having run through the relevant documentation. It's also noted at the end of that paragraph that no evidence was produced by the appellants to show that there was any other purpose involved other than obtaining capital allowances without suffering any economic burden. I said there were 4 things I wanted to do in relation to the FTT proceedings. We've looked at the grounds of appeal, we've looked at the statement of case, we've looked at the skeletons, we've been looking at the facts section of the FTT's decision, and I now want to move on to the, as it were, the decision section of the FTT decision. So against that backdrop and against the documents and the submissions that have been made, the FTT determined the appeals. And in doing so, I say it's clear that the FTT was determining the position in relation to section 11. What I'd like to do is give the court a number of references. So we're within the decision section of what's, if you like, called the Ramsey issue, or the substance and reality issue. And this is FTT's decision 76 onwards. Specifically, within the decision aspect, so this is part D, there's a heading submissions, which runs from paragraph 76 to 229, and then there's decision, which runs from paragraph 230 to 278. So, 2 things I want to do. First of all, refer to the FTT reciting the argument of parties. Secondly, deal with the FTT's deliberations and decision in this part. So within this submission sections under the heading Ramsey, a number of paragraphs that one could note. The ones I'm going to go to are, first of all, paragraph 159. So page 143 of the bundle. Mr. Peacock said that as in BMBF, the case, in these cases, there were very real events in the form of sale of ownership of assets, leaseback, the reacquisition of ownership, the assets pursuant to the put option. In his view, the effects of these real-world events should be respected for for the purposes of applying Section 61 and Section 11, just as the real acquisition of ownership of the pipeline for use in BS trade was respected in that case. So that's a clear submission that what my learned friend calls very real events and real world events should be respected when it comes to applying Section 11. Another example, para 175. Again, this is recording a submission from counsel for the taxpayer. It initially is talking about a case called Ensign, but if one picks it up towards the end of the paragraph, 5 lines up, yes, so he said that Section 11 is similarly concerned, so this is my own friend's submission, he said that Section 11 is similarly concerned with the purposes of the expenditure and any wider purpose the appellants may have had in entering into the related transactions is simply irrelevant. In his view, on that basis, the requirements of Section 11 were plainly met when the appellants reacquired the assets on paying the option price. Their plain purpose was to acquire the assets for their trade. So again, we've got a submission being advanced both as to the proper construction of Section 11 and its application on the facts of the case. A submission is being made that the nature of the purpose requirement, well, a submission is being made regarding the nature of the purpose requirement, and it's also being said that in the incident case, Section 11 is, quotes, plainly met. That's necessarily both a legal and factual contention.
Just going off at a tangent for a moment. So Mr. Peacock is submitting that the plain purpose was to acquire the assets for use in their trades. Would you accept that? I mean, it doesn't answer your Ramsey submission. Do you accept that at the stage at which the taxpayers, so to speak, reacquired the assets, their purpose was to acquire those assets for use in their trade?
Well, this is where one gets into what's common in these cases, where one can look at matters in more than one way. I mean, in one sense, and this rather simplifies, but in one sense, there's no dispute about the specific events that occurred. And indeed, we have the factual findings. And as the Upper Tribunal said, neither party sought to query those factual findings. So there's no dispute about the particular events that occurred. The dispute is about how to interpret them.
And I do follow that. So Mr. Peacock will tell me I'm wrong, but in a broad sense, plainly the taxpayers were engaged in schemes to achieve tax advantages. That was the overall purpose of the schemes. As you work through the different stages of the schemes, I wouldn't have thought it surprising if at the point at which the taxpayers reacquire the assets, that's what they want to do.
Yes, so, I mean, ultimately one comes back to the source. And I don't want to prolong the hearing, but in the case of Ramsey, this is exactly what was going on. The short point was the court obliged to look at a transaction salami sliced, piece by piece, to work
and
out
that
the
seems
truth?
to be a legal question rather than necessarily a factual question.
Yes, I mean, it may be both, but the basic point is that, I mean, as the Supreme Court says in Tower, what you're looking for is, as it were, the real purpose. What you're looking for is what's really going on here, and that might involve sort of stepping back and having a slightly wider lens, rather than saying, right, if I look at this chain of 18 events and just look at number 13, then a particular outcome arises. It ties in with what I said earlier about the ultimate question being whether on a purpose of construction the facts viewed realistically and the legislation tie together. If the legislation is saying just look at one element out of 10, then that may reach one outcome. if the proper interpretation of legislation is to say, well, if you've got something that works together, look at it as a whole, then there may be a different outcome.
Isn't this a question of statutory interpretation, really? So what you were arguing, as I understand, was that you looked at the composite whole, and I think, and I put it a bit simplistically perhaps, what the UT said was the FTT had got it wrong by sliding into looking at the composite whole, and what it should have done is taken a much more analytical approach to section 61, which was what was an issue there, and what the section 61 legislative question was. Isn't really the point of what you're arguing now to say, well, we need to therefore look at section 11 and understand the legislative purpose behind section 11, and does section 11 require you just to look at a slice of time, or does it require you to look at the whole transaction and ask whether the expenditure has been incurred taking account of the whole, everything that's gone on?
I wouldn't disagree with any of that. I suppose the point I'd add in addition is that it's true to say that what the Upper Tribunal was doing was to say, well, look, if you look at section 61 and we say you do need to home in on section 61, then a particular outcome follows. And I'm slightly jumping ahead, but I'm happy to deal with it now. There's an error in there, which is what we'd like to talk to this court about if we're given permission, because on the one hand, there's basically two propositions within the Upper Tribunal's decision which I say show that there's a problem. On the one hand, the Upper Tribunal thoroughly recognises that what used to be called the Ramsey principle is now essentially just orthodox application of modern purposive construction. And it's not something one switches on or off. It's something which is always there. It's ever present when one looks at any legislation.
But different pieces of legislation may have different consequences. That's the point. You need to work out which bit of legislation you're looking at, don't you, before you start construing it. And that might be said to have been a problem at the FTT.
No, absolutely so. But the point I was going to make is, on the one hand, the Upper Tribunal recognises correctly that you don't simply switch on and off this approach to statutory construction. But then, on the other hand, seems to take the view that once one's looked at section 61, there's nothing else to look at. We come back to the point that section 61 is a necessary condition, it is not a sufficient condition to get home, and that's clear from the FTT's decision. Yes, the taxpayer needs to succeed on section 61, but doing so doesn't mean they just walk over to the podium and pick up a winner's medal. So, we were within the FTT's decision, and what I'm trying to say is that the FTT recorded submissions that were made in relation to section 11. We've been to 159, we've been to 175. They also record submissions that were made by the revenue. So, for example, at paragraph 81 within the FTT's decision, one can see a paragraph beginning on that basis in Mr. Milne's view. And if one looks at paragraph 81 2c, which is over the page, the court will see what is said there in relation to section 11. In fact, the monies each appellant used to fund the price were monies put into a loop for the purposes of a tax avoidance scheme, by analogy, the tower. Now, your lordship might well say, well, hang on a second, Mr. Davey, we've got these words, it follows, at the beginning of 81.2. And again, I don't shy away from that. I don't shy away from the fact that it was a logically coherent submission, and if the revenue succeeded on 61, then matters followed from there. But I do say it's not the right way to read it, to say that the revenue is to be understood as conceding section 11, because they don't do that. I've been to our skeleton argument. I've also been to here to show what we're saying is, what's happening here? Well, it's money going in a loop for the purposes of a tax avoidance scheme. It's exactly the point on which the Supreme Court determined the case in Tower. So yes, section 61 plays an important role, but it's not the only show in town. Also 178, where we see it said that, as noted, Mr. Milne did not dispute the need for the tribunal to adopt a close analysis of the relevant provisions, or that when assessing whether the requirements of section 11 are met, it is the purpose of the expenditure which is relevant. Perhaps the court would just be kind enough to read or remind itself of the remainder of that paragraph, 178. So we have the tribunal setting out a revenue submission. That's a submission that locks horns directly with a taxpayer submission at 175, again on section 11. And then the tribunal is noting that it will come back to look at this in the decision part of the judgment. Final sentence there, I have commented further on this in the decision section. And that's referring forward to paragraph 261, or including 261, which we'll come on to in a moment. So, the tribunal records submissions that were made on section 11, and then it goes on to make findings. So this is within the decision section of, as it were, the Ramsey or substance and reality issue. And I'd like to go to paragraph 245. So we're now in the decision section, which begins, for the court's note, at 230. So at 245, we see the tribunal expressing its view as to how section 11 is to be interpreted and understood under the heading purposive approach to the CAA. And if we pick up 3 or 4 lines into 245, 3 lines up from the bottom of the page, it is central to a taxpayer's entitlement to claim allowances under section 11 that as these requirements have been interpreted in cases such as Ensign and Tower, it really incurs capital expenditure for the real purpose of acquiring an asset for the purposes of its trade. And it goes on from there. The FTT analysis then continues over subsequent paragraphs. At 246 and 247, it's principally looking at section 61. And at 248 and 249, the tribunal refers to the need for there to be coherence between 61 and section 11, third line within 248. And at 249, one also sees the FTT stressing that what matters is real-world events and refers to the interrelationship between 11 and 61. That's 4 lines up from the foot of the page. So it's clear that section 11 is being considered, and not in some vacuum or simply in passing. It's an element within the FTT's analysis. And the reason it's an element within the FTT's analysis is because it's dealt with in the grounds of appeal, it's dealt with in the statement of case and skeletons, there's documentary evidence on it, and there have been oral submissions on it. 250 to 259 is a detailed analysis of various aspects of the arrangements. And then if we pick it up again at 260, page 168, we have a paragraph that draws threads together and begins in conclusion. And the FTT is drawing a conclusion on the basis of what it calls a realistic and unblinkered view of the facts, including that section 11 is not engaged, beginning of page 260. If we go to 262 and 262b, so we can see it being said.
Sorry, yes,
263.
260's subparagraph 2b.
Yes,
rather than paragraph 262, it's paragraph.
I do apologise.
Yes. No,
paragraph 260,
yes.
sub 2,
Yes.
sub b.
Yes.
So in fact, the jumping off point at sub 2, viewed in the context of the overall plan, and then to b, the appellants did not incur the option price as capital expenditure on the provision of the assets for the purposes of their respective trades, and they did not own the assets as a result of incurring the sum within section 11. Also within 261, in my view, the decisions of BNBF, Ensign, Tower do not assist the appellant's arguments. And one sees at the end of 261, in Tower, Lord Walker expressly rejected the view that Section 11 is resistant to a composite approach. Again, this is the FTC engaging directly with Section 11 head-on and citing the leading case from the Supreme Court on it. At 265, we see it said, first line and second line, the appellant had no commercial business purpose at all. And that tallies with a finding we looked at earlier. It was 75, at the very end of the facts section, which spoke about the appellant's sole purpose being to obtain capital allowances. That was FTT, para 75, which itself was a factual finding based on what the FTT called the design and economics of the scheme, para 75. And a final reference from the decision, if and insofar as assistance, paragraph 23 is a summary of the conclusions of the judgment. So paragraph 23, page 108. And included within that short paragraph, let's see, is a finding that the appellants did not incur any further qualifying expenditure when they reacquired the assets for the purposes of Section 11. So that's the position before the FTT. It's a long decision, but as I've shown, it was a feature of the grounds appeal. It was a feature of the statement of case. It was dealt with in the skeletons. There was the contractual documents. There are factual findings. There are recitation of submissions, and there are decisions by the tribunal, including referring to the case law. That's where we were in the FTT. So it's not Judge Morgan's sort of blue sky thinking that she might just for fun refer to Section 11 as she goes. It's a careful and long judgment in which Section 11 plays a role. What happens next when we move from the FTT to the UT? Well, the very shortest answer one might say is, in a way, what happened next, in one sense, doesn't matter. It was the FTT decision, which was the fact-finding tribunal. We say the FTT got it wrong, got it right. We say the Upper Tribunal got it wrong, and we'd like to come before this court to restate the FTT decision. A slightly longer answer is that if one tracks it through, again, Section 11 remained in point. Could we go to the taxpayer's permission to appeal application, please?
Can you really say it remained in point in the particular respects that you're now trying to rely on in ground 2?
Yes, my lord, I do say that. Okay. Could we please go to Supplemental Bundle 2, tab 12? So this is the application for permission to appeal. But I should say, my lord, if I'm wrong on that...
You say it doesn't matter.
I'm going to say we should be given permission anyway, so I'm not going to shy away from it.
No.
This is the appellant's application.
I have to say, in terms of prejudice, I can't see that the Upper Tribunal stage can matter.
Indeed, my lord, and that's my primary contention. So, application to the Upper Tribunal, tab 12, Supplemental Bundle 2, starts at 303. This is the taxpayer's application for permission to appeal. And then within that, if we go to 316, so page 316, one will see paragraph 19, and this sits within a section, which one goes back a page, the FTT erred in imposing a purpose test. And at paragraph 19, it is said, further, the FTT's related reliance upon section 11 in order to justify such a purpose test is wrong in law. So the appellant companies are specifically saying that the tribunal relied upon section 11 and reached a conclusion which it says was an error of law. So the idea that section 11 was not live before the FTT I say is demonstrably false. And the idea that Section 11 was not in point as the case headed from the FTT to the UT is also false, because the company themselves referred to it. I should also add, and I'm very happy to do this, but I'm just conscious of time. If one goes to the FTT PTA decision, so Judge Morgan's decision refusing permission, it's crystal clear that she considered she had been dealing with Section 11. I can go to the specific pages, or I can give references.
Given the time constraints, you better give the references.
Okay, so Supplemental Bundle 1, Tab 11, page 281, 282, 285, 286, 290 and 292. This is all Judge Morgan making clear that she had dealt with Section 11. Upper Tribunal decision, what happened there? Well, one thing that happened there was that the Upper Tribunal recorded at paragraph 38 that neither the appellants nor the revenue made any challenges to the FTT's findings of fact. And I say that's important because that was the fact-finding tribunal. It may be that one doesn't need to go into this today, and I've already referred to it to an extent. But the question then does arise, if there were no challenges to factual findings, how was there legitimate room for the Upper Tribunal to land in a different place from the FTT?
I think that must be a question for another day.
I think it is. In any event, we say they fell into error, and I've given a sort of a glimpse of why we say that in terms of two propositions within the Upper Tribunal decision, or two strains of reasoning which I say are slightly out of kilter. Ramsey applies to everything. On the other hand, there was just a laser focus on a single provision. I think given the time, I'll now go specifically to, I think I said I wanted to refer to 2 or 3 specific points. So what I've tried to do there is essentially say it was part of what was done below. Section 11 was in point. What is said against me, or what specifically might I need to deal with? First point arises out of my Lady Justice Whipple's order of December, where it is said, the issue for the court is whether to exercise discretion to permit argument at this stage, and that largely depends on whether the response would be prejudiced, which in turn largely depends on whether these are pure points of law. Now, the notion of a pure point of law chimes with the case law in this area. There's a number of cases that deal with it. They're in the bundle. I'll refer to one, Singh and Das.
I don't think you need to take us to authority
Okay.
on this.
That's fine. The point I wish to make is this. My primary contention is that this is case law which is dealing with new points. My primary contention is that this isn't a new point. But if I'm wrong on that, and it is a new point, then I say that we do get home and should be allowed to go forward. And I say that for these reasons. If one were within Singh and Das, this is paragraph 16 to 18. Paragraph 16 simply says an appellate court should be cautious, and that must be sensible guidance, but I say it's not a reason not to allow this through. Paragraph 17 raises 2 points. Would the point necessitate new evidence? I say no, absolutely not. The FTT found the facts over 40 or 50 paragraphs. The taxpayer company put in the documentary evidence it considered relevant to the case in circumstances where they knew they had to meet the requirements of Section 11. They had the burden of proof. They chose not to put in witness evidence. So it's not right that new evidence would be needed. We've got all the factual findings. They weren't challenged in the Upper Tribunal. No new evidence on the point is required. And the idea that new evidence, for example, would have been called in relation to, and I suppose this is going on to the second point within paragraph 17 of Das. Is this a case where things would have been conducted differently below? My answer to that is absolutely not. We've already gone through the documents which showed that it's in the ground of appeal. statement of case, skeletons, and then one gets to the hearing before the FTT itself. In terms of the purpose point within section 11.4, and if you like, one of the two ways in which we seek to argue section 11 now, I've taken the court to FTT para 175, where the submission was made on behalf of the appellant taxpayers that the requirements of section 11 were plainly met when the appellants reacquired the assets. Their plain purpose was to acquire the assets for uses in their trades. So that's recording the submission that, on the facts, the purpose requirement, such as it was in the learned friend's analysis, was plainly met. And that in itself chimed with an exchange on the transcript where my learned friend was asked about this. We can go to the transcript, or I can simply give the reference.
Perhaps we should just see this passage.
Okay. So, supplementary bundle, I think probably 1, tab 9. Page 180. So this is dealing with what the purpose of these arrangements were. And at line 15 on, so page 180 of the bundle, internal page 148, line 15, Judge Morgan says, you got some funding, you will probably accept there's a commercial effect, but are you going further than saying that there was some purpose that the appellants had in obtaining that funding? Mr. Peacock, no. Nor do we need to, because there is no purpose test here. This is not a main purpose test as you might find in what used to be paragraph 13 of Schedule 1. There is no purpose test in section 61, 11 or 67. Judge, so in your view that's irrelevant, Mr. Peacock. It is just irrelevant, yes. Judge, thank you for clarifying that. So the idea that the question of purpose never arose, and had it arisen they'd have done things differently, I say doesn't hold scrutiny. It did arise, and far from pray and aid that they wish they'd done things differently, they doubled down and said, no, it's irrelevant, save for the narrow sense in which it suggested there is a requirement of purpose. So that's purpose. What about on the provision of? The other way which we put the point. Well, again, we've covered this really. There's no dispute about the events that occurred. So take the example of Wiseman. There's no dispute that there are transactional documents which refer to certain milk production related items. The dispute is about the interpretation of the events that occurred. The conceptual content of the phrase on the provision of seen within the statutory scheme. Obviously, the Revenue's position is that if you adopt a purposive construction and an unblinkered three-dimensional view of the facts, then query whether what one is looking at is on the provision of plant or machinery, or whether what one is looking at is money going in a circle to have a particular tax outcome. But this isn't about new evidence. Not about new evidence. It's about the interpretation of the facts that were found. Final point in relation to Singh and Das is paragraph 18 of Singh and Das, which makes the reference to a pure point of law. And the point I want to make there is, within the context of this jurisprudence, a pure point of law is simply a point which doesn't require new evidence. And one can see that from Singh and Das, Notting Hill at paragraphs 27 and 28, and others. It's a point which doesn't fall within paragraph 17 of Singh and Das. So it's a point which doesn't require new evidence. And we say that is where we are. And so within those three criteria of paragraph 18 of Singh and Das, has the other side had notice? Yes. They've known about this point for 6 months, and by the time of the appeal hearing, they'll have had it for more than a year. Is there any detrimental reliance? We say no, and I'll deal with the high watermark of their point, which is the final thing I want to say, deal with the high watermark of their point on that in about 15 seconds' time. C, could costs provide adequate protection? C, yes. So we say we get within, if we're within the new point regime, and we say we're not, but if we're within that we say there's a proper ground to say that we come within the principles and should be allowed through. No need to establish that the case is exceptional. Notting Hill at paragraph 26. Just in the exercise of the court's discretion, is it appropriate to allow the point to be run for the the reasons I've given, I say it is. So, final point. The other side say that there's a particular transcript reference which is very important and shows that everything I've said is wrong. So I need to deal with that. Could we go to the appellant skeleton? Bottom of page 14, top of page 15.
When you say appellants,
I do apologise.
You mean the
taxpayer company's taxpayer company's skeleton. I don't think it's in the bundle, but if the court has it to hand, it's the foot of page 14 and it's the top of page 15. And it says this: in response to questions from Mrs. Justice Fulk, as she then was, Mr. David Milne confirmed that the Revenue's issue 1 argument was predicated on section 61 only. There's then an extract, and then it's said over the page, this is important and must be read in context. And then underlined, after being pushed on the point, the Revenue explicitly recognised that the issue 1 case was limited to the application of section 61. Now, my overarching submission is that this extract does not come close to bearing the weight that my learned friend would wish that it does. Let me make that good briefly. First, this is a brief oral exchange. It takes place over a matter of seconds out of 5 days of tribunal time, 3 in the FTT, 2 in the Upper Tribunal. There's nearly 800 pages of transcript. It's not an application to amend, it's not a pleading, it's not a quote from a pleading or anything like that. And to state the obvious, it's being made after the event. This is after the FTT has already found the facts and made its decision. Secondly, in circumstances where the other side wishes to say that this establishes determinatively that reliance on section 11 is a new point, one thing your lordship and ladyship will note is that the question asked by the tribunal doesn't refer to section 11, and the answer given is not, we hereby drop reliance on section 11. As ever, context is all important. In the lead up to this passage, if the court wishes to go to it, it's tab 21 of the supplemental bundle, but I can make the point without going to it if that's more efficient. But in the lead up to this passage, so the immediately preceding, perhaps we should go there. Page 583, supplemental bundle 2. So in the immediate lead up to this, so we're on page 154. The passage quoted in the skeleton's line 13 and following. Sorry, 583, page 583 of the supplemental bundle. Internal page 154, starting at line 13, that's what's quoted in the skeleton. But if one goes up to line 6, you can see Mr. Milne is making a submission on section 11. So we say it can't seriously be put forward that any further expenditure that is incurred under this scheme is incurred as mentioned in section 11.
but immediately before that is said, if we are already the owner of it, you can't incur expenditure again if you are the owner of it twice. So we're back to ownership.
He is saying that, and ownership is a facet of it. But my point is, there's a submission being made on section 11. The tribunal then says, sorry, your appeal is put on the basis of section 61, isn't it? Now, pausing there, that question itself is a rather odd question, because the Revenue weren't appealing at all. The Revenue had appealed on section 61, but the Revenue had won on section 61. And then we have the reply, yes, that's what we're saying, that follows it through, yes. So we've got, I say, a slightly odd question, and then we've got an answer that in my submission sort of doesn't totally connect with the question answer. It says that follows it through. And we then have the beginning of a sentence. Mrs. Justice begins a sentence. Yes, but the appeal is on the basis that section 61, but we never get to the end of that sentence. There's some over-speaking. We then have the words, the issue on appeal. And then we have the response, the issue is ceasing to own the equipment. That's right. That's what we say. And then absolutely crucially, see the next sentence. As I say again, we pray and aid everything that was said by Judge Scott in refusing permission in the first place for this, and we say his defence of what we would say is the analysis of the FTT is a valid one, and therefore we respectfully ask you to uphold the decision of the FTT. Would you like me to go on to other points? Yes. So he's making a submission about Section 11. He's asked about Section 61. He responds, and in responding, he's saying, have a look at what Judge Scott says. Now, I don't think we've got time to go to what Judge Scott says, but we can if the court would like, or I can simply give the references. But within Judge Scott's decision, if one looks at paragraph 4, 5 and 6, so bundle reference, supplemental bundle 2, tab 13, 434 to 436, what he's doing in refusing permission is setting out that the taxpayer's analysis, including in relation to Section 11, is rejected. The intended tax analysis did not follow. And Mr. Milne is saying, we rely on everything that Judge Scott says. So, again, it's not a case of the Revenue saying, for the avoidance of doubt, we're not interested in Section 11. Quite the contrary. In short, I say the idea that Section 11 wasn't involved at the first instance stage airbrushes the history. It's not the case, and so it's not a new point. But I also say if I'm wrong about that, nevertheless, permission to appeal should be granted. It can't be in anyone's interest that this court ends up hearing this matter, which it will do, without being able to have regard to both bookends, as my own friend puts it, both bookends of this key piece of legislation. And by granting permission, which I say is the right thing to do, both if it's not a new point, but also if it is a new point, because there's no prejudice, yes, is the way in which this court should exercise its discretion. There's more I wanted to say, but I'm watching the clock and I do apologise, unless I can assist.
Can you just remind me, I've got open the Scott refusal of PTA, but I failed to note the paragraphs that you wanted us to look at specifically.
So I would ask that the court reads paragraph 4, where it's referring to the FTT decision, where the transactions are summarised. Paragraph 5, quoting from the FTT, setting out the appellant's view of the correct analysis, including in respect of Section 11. And then paragraph 6, with Judge Scott recording correctly that the FTT rejected that analysis.
I wanted to ask you about one other reference in the FTT as well. Much of your paperwork prepared for today suggested that Section 11 was either raised as part of Issue 1 or as Issue 4, as it once was, and you haven't touched on Issue 4. But I just...
For the avoidance of any doubts, the Revenue is not running Issue 4 and made that clear to the court and the taxpayer 6 months ago. It's a typo that it sits within the notice of appeal. So we wrote to the other side in September.
Okay, I think I've got that. This is a short. This may just, you may say to me this doesn't matter, but I wanted just to ask you if there was anything at all from paragraph 298 of the FTT on page 180 of the core, which I think is in the section dealing with Issue 4, which sort of had some Section 11 crossover. And para 298 records that HMRC reverted to raising the same points they made in relation to Ramsey as to why the requirements of Section 11 aren't satisfied in relation to the option price. And that struck me as being a sentence that reflects what you're arguing now. I mean, I don't think any findings were made on it, but I just wondered if that was the very point.
And that is correct, my lady. I've made a point of not going to the Issue 4 element of the FTT decision, precisely because we're not trying to run Issue 4, and I wanted to show it's full-throated enough within the non-Issue 4 part, but it's quite right that this is a relevant reference. Ultimately, one has to strip away the labels of the issues and ask what the legislation is doing. And inevitably there's a bit of an iterative process. You look at different questions, you quite often come back to the same point. I do apologise for the length of time I've taken. It's quite a lot of ground to cover, but unless I can assist further, those are my submissions.
Thank you very much. Mr. Speaker.
Well, Lord, I propose to address the court briefly under 5 headings. Firstly, some introductory observations. Secondly, to touch briefly on the relevant principles. Thirdly, to look at this case, the big picture. And then fourthly, to look in more detail as to why these are new points and should not be permitted. And then lastly, I want to pick up on some of the things that have been said by my learned friend either in writing or today this morning. So, the first of those, some introductory observations. You've heard a degree of sound and fury from a learned friend, both in writing and oral this morning, about the nature or characteristics of these transactions that were entered into in 2010. None of that is material to the question this court must decide this morning. Moreover, my learned friend hugely overstates or mischaracterises the position. We were below and will be on appeal concerned with some complex capital allowance provisions which were introduced in 2006, largely by reference to statutory algebra, and those statutory provisions did not work well in 2006 and were amended throughout the following years, including by an amendment made in 2011, which would prevent the transactions having, the present transactions having the result that is sought for them. All of that is neither here nor there for this morning. If you want to get a better understanding of what the parliamentary purpose was here, then I commend to you the particular paragraphs of the Upper Tribunal decision where Her Ladyship below identifies that what is now complained of either was or may well have been Parliament's intention. And that is paragraphs 51 through 60, core bundle, page 56 onwards, and she deals there with a more accurate view of the surrounding analysis. But as I say, that's not material for today. What we have today is a classic example of appellant's remorse. They now wish to run a case that is different to the case that they ran below. No amount of sleight of hand by my learned friend will disguise that. Secondly, as to the relevant principles, they're set out in the skeleton arguments. I don't understand them to be in dispute. The court has them. I say, I think no more about them at this stage. The court well has in mind to ask whether these are new points, to what degree would they involve consideration of matters of evidence, or where the trial by the fact-finding body would have been conducted differently in relation to the evidence. Both of those are highly material factors where what is sought to be advanced on appeal is, on close analysis, a new point. So I'll say no more about those. I can pass to my third heading. In this case, the big picture, we say these are new points. They do involve matters of fact, and the appellants here should not be permitted to run them, not least because the revenue do not find themselves in this position by accident. The Commissioners made a conscious decision below, no doubt on advice from very experienced leading counsel, to run particular arguments and not to run others. And indeed, when this very issue became a live possibility in the Upper Tribunal, as you have seen just a moment ago, my friend Mr. Milne was specifically asked to confirm the ambit of his Section 61 argument, and he did so in terms. I'll come to that in just a moment, but he was there specifically confirming that he was only running the argument that is in fact the one that the Upper Tribunal goes on to address. There is no doubt that my lady below understood Mr. Milne's answer. And I don't think we need to turn it up, but you do need to read the whole of that exchange, starting from transcript page about 152. but there was no doubt to anybody who was in that room at the time, nor on a fair reading can there be any doubt on reading the transcript now, as to what was understood by both the question to Mr. Milne and the answer he gave. So these are new points that could and should have been raised below, we say, and it is simply too late for the commissioners now to run what is in effect an entirely different case. That's the headline of my answer. That takes me to the fourth of my 5 headings, which I'm afraid is a little more detailed. But we do need to look at what is superficially a complex history to see exactly what the commissioners said and when, and in particular what reference was made below to section 11. Now, you've seen from Learned Friend and even the materials he's taken you to that section 11 is in the transcripts, it's in the arguments. But it was only ever put by the commissioners in 2 regards. In the context of what was then styled issue 1, did you cease to own, for the purposes of section 61(1)(a), there was a point I made, this is the bookends point, that you had to understand what it meant by cease to own in section 61 in light of the provision that gave you the allowances at the outset, i.e. on the original acquisition of the kit. And my point was, you get allowances under section 11 when you bought the assets, and you have to understand that that was the starting point when you come to construe what it means to cease to own. So there is a reference to section 11 in that bookends context, but it's a different point. It's not looking at the reacquisition under the option. That argument under issue 1 was that there was no cessation to own, and therefore there could be no section 11 reacquisition. And that was said to follow as a matter of statutory logic, if you like. And if the commissioners were right that there was no cessation to own, everything else fell away. And we have always accepted that that would be the case. But it was never said, as part of issue 1, that the commissioners had some kind of fallback, that if they were wrong about ceasing to own, then for the purposes of issue 1, the requirements of section 11 on the reacquisition were not met. Now, logically, that contention doesn't really form part of issue 1, because issue 1's about the cessation to own. But whether one thinks of it as conceptually fitting somewhere else or being shoehorned into issue 1, it was never any part of issue 1. The contention was you didn't cease to own, therefore you could not have reacquired. There was no consideration of whether the terms of section 11 were actually met. In the context of issue 4, so the sum paid under the put option, it was said by the commissioners that that amount cannot both be a sum taken into the statutory algebra of QE minus QA, and also form the amount which would satisfy section 11 on the reacquisition of the kit under the put option. But this contention was not that the terms of section 11 were not in fact met, but that the same amount could not do double duty, couldn't be counted twice. So issue 1, the commissioner's case, was you can't have bought the kit because you never sold it. And issue 4 was the option price can't be counted in both provisions. But the commissioner's case below, and I'll show you this, was that we did satisfy section 11, and it was for that reason that we couldn't satisfy section 70E. Now, to jump a little ahead, the commissioners did apparently appeal issue 4 to this court, it's included on the form. They then emailed us to say, as they did to the court, that they were abandoning issue 4. What my lady has given them permission on is to pursue the you didn't cease to own point. And if they're right about that, to reiterate, we have always accepted that there couldn't be a reacquisition. If they're wrong about that, they have never, until today, run a fallback argument, call it issue 1.1. If they're wrong about that, then the requirements of section 11 are not met. So, pausing there, the revenue lost on issue 1 and issue 4 in the Upper Tribunal, and they're only pursuing issue 1. And that issue 1 has only ever been put in terms of you can't have bought because you never sold. Now, this next exercise is a little detailed, but I'll do it as quickly as I can. One goes back to the correspondence, so there is the final statement of the Commissioner's stance against which we appealed. What was said was, in this regard, you didn't cease to own, therefore you can't have reacquired, and the option price can't be counted twice. And it was that we appealed against in our grounds of appeal to the first tier. I don't think we need to turn this up. It's supplementary bundle tab 1 at page 15. The contention we were meeting is not the one that's now advanced. The revenue statement of case, core bundle page 197, in particular at pages 206 and 211, are again the contentions. You didn't cease to own, therefore there's no acquisition, and the option price can't be both. That is reflected in the statement of agreed facts and issues, supplementary bundle tab 27, in particular at pages 618 and 620. And that is exactly how the case was put to the first tier. One can see that. I'll just give you the first tier paragraph references, but it's at 19, 76, 81, 235.
19.
76,
Yep.
81, 235 and 260. And those are all paragraphs that make the point you didn't cease to own, therefore you can't have reacquired.
We're in the statement of facts and issues, are we?
That's in the first tier's decision.
TT decision.
Yes, the statement of facts and issues are
Sorry, I just
supplementary bundle at 618 to 620. First tier is in core, and I can give the core the page numbers if that would help, but those paragraph numbers will find the point. And the contention that you can't count the option price twice appears in the first tier at paragraphs 293, 297, and significantly 311 to 312. I say significantly for this reason. It would be helpful if we just turn up the transcript for the first tier, which is in the supplementary bundle, tab 9. And in particular, it's page 169. And in particular, internal page reference 103, lines 13 to 17. It's the left-hand page of those bottom two pages. My learned friend is saying there that the requirements of section 11 were met. Just to give you context, Commissioner's case was he can't be in 70E and section 11. That was a point of statutory construction, statutory interpretation. was not said you don't, as a matter of fact, meet 70E or 11. The assumption was you met both. Now, when pressed, Mr. Milne's preferred stance was you do meet section 11, but that tells you why, as a matter of statutory construction, you can't be in 70E. So there are references in the transcript to me saying, if there's any doubt about this, we do meet section 11. Because on the reacquisition of the kit by paying the option price, we needed the kit back again. But Mr. Milne is saying, yes, you're right about that, but you can't count it twice.
I mean, I'm sure you're coming to this, but there are two stages to this debate. One is how far is ground to a new point. The other is, supposing it to be a new point, are you prejudiced?
Yes.
And in that context, what Mr. Milne was saying isn't necessarily an answer to anything. That tells you what the revenue were running rather than whether you're prejudiced.
I'm going to come to that, my lord, but it's important to see how the argument was put below. Now, maybe the court is ahead of me, but I do want to make crystal clear that this is a new way of putting it.
Yes.
But that's what explains, if we look at the first tier decision, which is core at page 179. Paragraph 296, you'll see the tribunal judge recording the revenue submitted that. And then under subparagraph 2 of 296, there's a sentence that begins about 6 lines down on the right-hand side. At this stage of the analysis, the revenue are proceeding on the assumption that their Ramsey argument is not accepted. On that basis, the better view is that on paying the option price as consideration for the relevant assets for the purposes of section 11, the appellants incurred qualifying expenditure of that sum. So that was the judge understanding what Mr. Milne had said in argument. And then at 2971, again, this is recording what Mr. Milne had to say. 297 sub 1, as noted in the revenues due at this stage of the analysis, the better interpretation is that given that it was always the intention for the assets to end up back in the hands of the appellants, the option price constituted only qualifying expenditure within the meaning of section 11. Now, he's saying that to set up the argument that you can't be in both. But there was never any debate between us that the requirements of section 11 were met. And then if we look on, to save me coming back, at 311, page 183, the tribunal recites in effect Mr. Milne's "you can't be in both" point. And then the judge says, I cannot see any viable basis for the revenue's view that if you're in section 11 you can't be in 70E, or if you're in 70E you can't be in section 11. So she's rejecting that argument as a matter of law. But in doing so, it's important to note at 312 subparagraph 1, she states that the individual requirements of 70E and section 11 are met. Then subsection 3 begins, similarly, I cannot see any justification for concluding that where its requirements are otherwise satisfied, section 11 is not intended to operate where a lessee repurchases. So she proceeds there, on the basis of what she'd heard from Mr. Milne, that the requirements of section 11 were met. So that's what the first tier decided. We then appealed because we'd lost on issue 1, and the revenue put in a respondent's notice to reiterate that they had an issue 4 argument that you can't be in both. And just for your note, that's page 472 of the supplementary bundle. And there is no doubt that the Upper Tribunal understood the revenue to be running two principal arguments relevantly for today's purposes. Firstly, section 61(1)(a) is not met because you didn't cease to own. And if that were right, you'd never get to section 11. And you can't be in both point. And that is crystal clear, we say, from the Upper Tribunal's paragraphs 21, 39, 41 and 47. And it is those arguments that ultimately the Upper Tribunal decide by deciding in our favour on 61(1)(a) and rejecting for in effect the same reasons my own friends Mr. Milne's then issue 4 argument. Now, what did Mr. Milne have to say in the Upper Tribunal about the limits of his argument? Well, you've been shown where he was asked by Mr. Justice Falk at the time, what's your argument on section 61? He says it's a cessation to own argument. But he also addressed his option 4 argument and the role in that argument of section 11 in the Upper Tribunal transcript, again in an exchange with the court. This is supplementary bundle, page 587, could be tab 22. So this is day 2 in the Upper Tribunal. Internal page 6, picking it up at line 7. Here Mr. Milne is dealing with the issue 4 question as to whether there's a glitch in the legislation that you can be counted twice. And again he makes clear between lines 7 and 21, 22, Commissioner's case is where you do meet section 11, but that's a statutory reason, statutory construction reason why you can't be in both. So there's no change in what Mr. Milne was saying in the Upper Tribunal compared to what he said in the First State Tribunal. And just in case you might have been left wondering, that wasn't some slip of the tongue by Mr. Milne. They say exactly the same thing in their respondent's notice to the Upper Tribunal, supplementary bundle tab 17 at paragraph 44, which is page 486. So stopping there just for a second, section 11 was mentioned in both the tribunals below. It was addressed in the first tier, but it was addressed in 3 contexts. One was the bookends point, comparing the original acquisition with the sale. That's just not material. The second was, if you didn't cease to own, therefore you could never have reacquired. That's a point of law which, statutory logic, we long accepted. Or in the context of issue 4, where it was not said against us that the requirements of section 11 are not in fact met. The indications from the commissioners were that they accepted that they were met. And that's how it was understood by the First State Tribunal. So there is no doubt, we say, that what is now said to be the commissioner's case, call it issue 1.1, is a fallback argument if they're wrong about issue 1. That even if there was a cessation to own, they want to run a section 11 argument under the heading of issue 1, brackets I say mildly critically, it doesn't really logically fit there, but so be it. There is no doubt that it's a new point. Now, does that matter if it were a pure point of law? You have the authorities, the relevant principles, even in those circumstances, you need to be cautious about admitting it. But what is said against us here is that we don't meet the purpose requirement of Section 11, nor that the acquisition expenditure was on the provision of the relevant asset. Now, you were shown a passage where I'd made some observations in the first year about purpose. My learned friend was taking those grossly out of context. What was put to me by Judge Morgan was whether I accepted that the transactions as a whole had a commercial purpose or a tax purpose or a main purpose or a sole purpose. That was the debate we were having. And I answered there is no main tax purpose provision, anti-avoidance provision, in Section 61 or Section 11, or indeed Section 70.
Can I just understand that? If we go back to, is this actually in keeping with what you had said in your skeleton? So if we look at your skeleton, which was tab 2 in the first supplemental bundle, we come on to issue 4, section 70E at page 76. And you work through various bits of it. You say 132, no legitimate basis for HMRC's assertion because section 70E isn't concerned with purpose.
Yep.
Even if it is purpose of lessor, section 11 turns on the reasons for the payment, not the transaction. And you say purposes are relevant, and then you come on to 138 to the end, where you're talking about section 11 dealing with reason for payment, not the transaction.
Yes, and those paragraphs are addressing a point that we feared was going to be made, even though that's putting it too high. Feared is too high, but we considered it might be made, that somehow the purpose of the transaction was determinative of the purpose of the expenditure on the reacquisition of the kit under the put option. And the point we're making there is that section 11 asks you about the purpose for incurring the expenditure. And that's the purpose of the reacquisition transaction, not what might be said to be the wider purposes of the transactions.
So you have in mind that it might be said, well, purpose is relevant here. You have in mind that they might say, well, we look at the purpose of the overall transaction. Supposing that you had thought it viable to say something beyond that about the purpose of the payment, well, why wouldn't you have done it?
This was to deal with an argument that was never in fact made.
But does that matter? Because the question in terms of prejudice is whether you had a reason not to adduce evidence on purpose. And you thought purpose could be in play, so therefore you had a reason to adduce any evidence you might have wanted to on purpose.
If one goes back to I'll call them the pleadings, if you look at the decision letter of the grounds of appeal, everything that led up to this document, there was no suggestion that section 11 was being run in any different sense.
I follow that, but you feared it could be. So you dealt with it here, and indeed HMRC answered it to an extent in the document we see at tab 5, tab 6, where they say, well, there wasn't any commercial benefit.
Purpose to the transactions as a whole.
To the transactions as a whole.
Now, had they said on day 1 of the hearing before the first year, or even day 2 or day 3, hang on a minute, we have a different section 11 point whereby we are going to change our stance and require you to prove factually the elements of Section 11, we would have said you did not make that point up to now, and we want the opportunity either to call evidence to deal with the purpose of the reacquisition, or to make submissions in light of the evidence to address that point.
Now, as to the latter, we can do that in this court. So the real question is the former.
Well, you can do that in this court, but you do not have the benefit, unless this court is going to give us the indulgence of crawling all the way through the transcripts. You don't have the benefit of having heard firsthand the arguments in the context of the evidence that was before the first tier.
And just pursuing it a moment longer, we see back at paragraph 15 of your skeleton, when you're talking about real commercial benefit, points put forward in relation to each taxpayer, which the tribunal evidently rejected.
Well, that's a benefit to the sale, my lord, not.
So we're dealing still with transaction. Well, the sale, yes, I see.
It's a
sale
benefit.
As opposed to reacquisition.
Yes, what was said to be the benefit, which ultimately the first tier reject, is that we raise short-term financing as a result of selling the kit.
Yes.
Now, the tribunal said, well, yes, you did get short-term financing, but it wasn't
That
an
can't
attractive.
possibly be the driver.
But it wasn't an attractive rate, so therefore that's not a driver.
So you say, on the revised case, what is crucial is the purpose of the reacquisition.
Yes.
Mr. Peacock, just to go slightly sideways on this, don't you get to that question once you've construed Section 11? Isn't there an episode you need? I mean, there are two elements to the BMBF test. One is construing the statute and then applying it to the facts and seeing if the statutory question is met on the facts. You can do them in either sequence. But conceptually, don't you have to ask yourself, what is Section 11 driving at before you know the scope of the evidence that might help you answer that question? There's nothing to stop us looking at Section 11, is there, and what it's looking at and construing it before we then come to think about whether there was evidence, what different evidence there might have been, and so on.
Well, my lady's observation is right that that is an iterative process, and there is an authority, I can't immediately remember what it is, that says you can do it in either order.
Yeah.
And I quite accept that. Yeah. But in order to form a realistic view of the facts, that is an exercise that should be done by the fact-finding tribunal.
Yeah.
It is a nigh on impossible task for this court to do. But more significant, my lady, because this point was not raised in the first tier, I haven't shown you the authorities yet, but Lord Justice Millett in Vodafone says the purpose of expenditure is a question of fact. On the provision of is said by the Supreme Court in Tower, Lord Walker and Lord Hope, to be a question of fact.
But post-construction, I mean, I'm not sufficiently familiar with those authorities, but isn't there a question about what you're looking at under Section 11? Are you looking at, to paraphrase it, the purpose for which the expenditure was incurred? So in this case, why you reacquired?
Yes.
Or are you taking into account a broader range of things?
It's the former, because under Section 11 you're required to identify whether the expenditure was incurred for the purpose of acquiring plant and machinery.
But isn't that precisely the point where HMRC, precisely the point they want to argue, isn't it? They want to say, well, that's not quite right because you import Ramsey at that stage or you BMBF at that stage, to say you ask yourself whether it's a real incurring of real expenditure, really to get the plant and equipment, or whether in fact you had it all along.
Well, one needs to be wary of references to real.
I'm only taking it from the case law, it's not me making it up. There are quite a few references to that.
There are, but I could find with half an hour's leeway, I could find lots of references to say you need to be wary of real.
Okay, no,
real
I take the point, but you see where I'm heading at.
I do. But the point is this, that if you're going to judge the purpose of the expenditure at the point of reacquisition, let's assume Mr. Milner said nothing. Let's assume the first tier had decided nothing. That would be a question of fact. And that is equally true of whether you've incurred the expenditure on the provision of.
Okay. So accepting that, what would you have sought to prove? Suppose that the case had been presented as Mr. Davey now seeks to present it. You say you'd have called evidence. What would the evidence have sought to prove?
We could have had somebody from each of Cape and then was and Robert Wiseman to give evidence to the effect that once the lease had come to an end and the kit was, absent other steps, no longer available, each of those companies would have wanted to reacquire that kit by exercise of the put option or the call option, whichever it turned out to be, so that that kit could continue to be used and the business is carried on by the taxpayers.
Isn't that just obvious? I mean, isn't it obvious they needed the kit? That was the whole point, is that Wiseman and Cape needed the kit to do the business. I mean, is that really in dispute? Could it be in dispute? Does it need to be in dispute?
It couldn't and shouldn't be in dispute. But if it's not in dispute, and let's also now factor in Mr. Milne's confirmation that that was the Commissioner's stance, and we have the first tier apparently deciding that as a matter of fact, and the Commissioner's never appealed that to the Upper Tribunal, nor to this court, that's the end of the point.
Well, then it becomes an issue of law. I mean, if we were to say to HMRC, look, you could have permission to appeal, but on the basis that it is assumed that at the point at which each option was exercised, the subjective intention of the company was to reacquire the assets so that they could be used in their businesses. Would there be any objection to that?
Well, I would say at that point, then the point's no longer arguable. That's an argument they are going to lose.
And then it becomes plainly an issue of law as to whether that is a relevant intention. I mean, I can't quite see how Mr. Davey can deny that at the point at which they were getting the equipment back, they will have wanted to get the equipment back. Well, then it's a question of law.
Well, he appeared to be denying it this morning, rather in the teeth of what Mr. Milner had said below. But if you put to him, and let's assume he confirms in a moment that yes, he'd accept that, then they are in a position that there are findings of fact in the first tier to that effect, which they have not hitherto appealed.
Well, they wouldn't be needing to appeal now because they'd be accepting that at the point of reacquisition, the directors subjectively wanted the equipment back.
Well, even that qualification, although I'm slightly wary of there being some wriggle room between an acceptance that it's the subjective intention and then it being said that that's not determinative. But let me put that aside for a second.
What other intention could you have given evidence about?
Consistent with the authorities, that question of purpose is one of subjective intention. That's what Lord Millet says in Vodafone. It's not put in terms of subjective intention, I don't recall, in Tower, but it is said to be a question of fact.
But if it weren't a question of subjective intention, you couldn't have given evidence about it anyway, and therefore you can't have lost the opportunity to do so.
We could have given evidence that would have borne on the tribunal's conclusion as to the purpose of the expenditure, even if it wasn't evidence of subjective intention.
What sort of evidence could that have been? I mean, on the face of it, everybody knows what was going on here. It's a question of whether that produces a tax consequence or not.
Yes, that at a high level of generality, yes, of course I accept that. But there are two possibilities. Because this point wasn't run, the first tier haven't addressed it, and at that stage I say it's clearly a new point, it does involve matters of fact, and it's too late for the commissioners to pursue. Or, in light of what Mr. Milne had to say below, it was conceded that Section 11 was met. The first tier has found that Section 11 was met, and there was no appeal. And therefore, again, I say it's simply too late for the commissioners to withdraw that concession so as to run a different argument on appeal. And although I can't really pretend that these are not new points, they clearly are, I don't hear him say they're not matters of fact. On the authorities, they clearly are. In those circumstances, the authorities don't say this court cannot grant permission, I accept. But they do say you need to be very wary about doing so.
We do it an awful lot. Where there is no prejudice, it's not at all uncommon for people to be allowed to run new points.
Well, I hear that, and each case must be driven by its own dynamic. But the one stands back in the first tier tribunal, these arguments just weren't wrong. In the upper tribunal, Mr. Milne was in effect put on the spot. There was no doubt in the room what he was being asked and what he answered. What my clients are concerned about is if this court were to give permission, and then in 6 months' time we get in front of, let's assume, a different panel, my clients will be prejudiced in some way by however the argument develops, in that we were never given an adequate opportunity, a fair opportunity, to address before the fact-finding body a point that is taken in the Court of Appeal. Now, of course, in all of these sorts of debates, there's a tension between wanting to allow points to be run that may help the court adequately decide the litigation between the parties. On the other side of that coin, there is clearly an interest in the finality of litigation and points being taken at first instance where they could and should have been taken. I quite accept this court has to balance those two competing demands. I do reiterate that permission should not be given here for the overarching reason that there is a grave risk, putting it as low as possible, a grave risk that we have been denied a fair opportunity to address these new points. Now, I was going to deal with the last section of my submissions with some specific points where I personally rather particularly agreed with what was being said. I think we've covered most of them. They're addressed in our skeleton argument, the appendix, where we pick up various points in the Commissioner's skeleton. I don't want to repeat them now by taking up time, but if you are minded to pay close regard to what is said in the Commissioner's skeleton, I do invite you to look at the appendix to ours. So unless there's anything else I can help you with.
Thank you very much, Mr. Speaker. Mr. Davey.
Well, I'll be extremely brief, just a couple of points. First of all, as regards issue 4, I say that is a red herring. Nothing I went to this morning was in relation to issue 4 or within the section of the FTT's decision which dealt with FTT, which dealt with issue 4, and we said some 6 months ago that we weren't running it. Crucial point is this: the premise of issue 4 was that the revenue had lost on the substance, reality, Ramsey analysis. And so if there are instances that can be found of Mr. Milne appearing to contemplate that Section 11 was or might be met, that's why one's working on the premise that one's already lost. And one reference, which I think my learned friend did go to, but it's paragraph 296, sub 2, third sentence of the FTT decision. 296, sub 2, third sentence. The revenue are proceeding on the assumption that their Ramsey argument is not accepted. So I do say issue 4 is a red herring, it's not the answer. Second point is that it needs to be remembered the appellants bore the burden of proof before the FTT. It was their appeal. It was for them to establish they fulfilled the requirements of the legislation, including marshalling such evidence as they thought they needed to show that they did. That's not a question of seeing what an advocate says on the third day of a trial. That's not how it works. They bore the burden of proof. They had to show that they got through the various hoops that the legislation set them, and it was for them to decide what they needed in order to establish that. They put in all the contemporaneous documentary evidence, and we've been through that. I could say all sorts of interesting things about Millet and subjective intention, but perhaps now's not the time.
Well, can I follow up on that?
Yep.
You'll have heard me raise with Mr. Peacock the question of whether you would concede or possibly we should grant permission only on the basis that at the point at which each lease was at an end, each taxpayer subjectively wanted to reacquire the kit so that it could continue to be used.
Well, I suppose the formal answer is that I'd be grateful for the chance to take instructions. The slightly less formal answer is that I don't think there's any issue that if you are, let's take Wiseman as an example. If you are the Wiseman company, you need that kit to produce milk. I don't think that's an issue. The question is the relevance or otherwise of that fact in the context of the statutory scheme.
And Mr. Peacock says once that's conceded, you've lost the case. But for the purposes of our deciding on permission to appeal, we might think that that issue of law can be deferred to the full appeal. That would be a more attractive course if we could say to ourselves when the scope for any dispute about fact has gone away, because it is, as you say, plain that at the point at which there was a reacquisition, the companies will subjectively have wanted the kit back.
Yes, so I suspect the answer is, well, certainly no issue is taken with any finding of fact made by the FTT. It wasn't in the UT. No one's trying to do so now. I'd be surprised if there's any debate about the fact, as I say, if you're going to produce milk, you need a bit of kit that produces milk. So, as a slightly long-winded answer, I probably should take instructions, but I suspect the answer is happy to sort of agree the fact pattern and have it dealt with as a matter of law.
Can I press a little bit further? Because I'm not sure I've quite got in real focus what this point is, your ground 2. Is it a suggestion that when you get to the reacquisition stage, which engages Section 11, the incurring of expenditure, that you have to construe Section 11 and ask yourself what actually is the statute looking at, to the effect you would say that you are looking at more than just the narrow transaction of what is reacquired or acquired for what money is spent, and not even looking at purpose and provision, not even, you look at it in a broader way, so that you would need to look at the whole sequence of transactions to understand the full colour. Is that along the lines of your argument? So that's as I'd understood what you wanted to be arguing at that point.
That's right, milady. I mean, what one could do, I don't think now's the time, but if this were to go to the Court of Appeal, we would spend time looking at the case of Tower, where they have to do exactly the same thing,
that's what you're
and Lord Hope sits back and says, you've got to ask, what does this legislation, and it's section 11 itself, you've got to ask what does this legislation demand of one if you've got a composite scheme. So I won't repeat where the Supreme Court got to on Tower, but they've essentially said, looking at this legislation and looking at these facts, which weren't, I mean, it was clear what had happened. The question is, what was the correct analysis? They ended up saying, well, you know, the real purpose is money in a loop for a tax avoidance scheme. And they also said a lot of other things as well. So I think my answer to your question is yes.
Yeah. So if that's where you get to, and I'm sure one could finesse the language a bit more, and I'm sure Mr. Peacock in his bones is troubling at the way that it's being articulated by me, but I'm trying my best. That feels like an issue of law between you as to what is the appropriate analysis. It's not that any facts as found are going to make a particular difference. It's doesn't it boil down to whether you take a wide view or a narrow view of what the legislation means? Do you just look at what's in front of you, the reason why they bought their equipment back, or do you take account of everything else that's gone before?
I don't disagree with the sentiment of the expression. Questions of wide and narrow, as your ladyship knows, someone has to sort of unpack conceptually what that means, but the sentiment I agree with, yes. It is ultimately we do say we'd like to go to the court to talk about matters of law, not matters of fact. The facts have been found. The facts aren't in dispute.
Well, there isn't a
Isabel
fact
Brano
found.
has a point for you at some stage.
This is always an exciting moment when one's handed something and simply goes to it. If it's okay, could we go to para 255 of the FTT's decision? In short, it's the first sentence of 255. We have a factual finding. I mean, that's the point in a nutshell. That is the finding. Question is, what role that piece of the jigsaw plays.
I mean, building on that, if ultimately we said you could have permission to appeal, but on the assumption, which I think you're saying would be in line with this, that at the point of reacquisition, the subjective intention of each company would have been to acquire the assets to use in their businesses or whatever it is, that would still be something you wanted.
Well, I think that's when we do get to talk about Lord Millett and Vodafone, because it's true that he said it was a subjective question. He also said, in the same case, same page, that some consequences are so inevitable, so inextricably linked with what one does, then they must be taken to have been a purpose.
I mean, at that point, though, we're outside what the taxpayers might have wanted to call evidence about, presumably. I mean, they could have called evidence as to what they subjectively intended. There might then have been or be a further legal argument as to whether or not the subjective intentions determine matters, or whether, as you say, you have to take into account something that inexorably goes with it.
Precisely so. It's a legal point regarding, well, I suppose the conceptual content of the notion of purpose. But it's a legal point, and it's a point made by Lord Millett in the same passage that's been referred to.
So if we were saying, well, you can only have permission to appeal on the basis that it is taken that subjectively the taxpayers would have wanted the kickback, you could then have legal arguments as to how that fitted into Section 11 and Ramsey and Lord Millet.
One could, with the fractional caveat that it does depend what one means by subjective, and indeed Lord Millet says it doesn't exclude subconscious motive. So one does get into quite fine questions of what is subjective, what is objective. Is a subconscious subjective aim the same as an objective aim? One sort of steps back and just looks at things dispassionately. But I think that's actually a question of language. I think the substantive point your Lordship is making, I'm not disagreeing with, I'm agreeing with. We don't deny there was kit. We don't deny that if you want to move milk around, you need a lorry, and so on and so forth. The question is, as I say, what role does that piece play in the overall jigsaw? And the analysis of the overall jigsaw is a legal matter. It's the legal matter that we're interested in and seek permission on.
Well, if I might just interject into this debate, just one observation to my lady, that the way that my lady put it a moment ago, I think is different to the way my learned friend is putting it. My lady suggests that one might have regard to wider circumstances. Now, that seems, for my part, to engage a wider consideration of the facts than merely the subjective desire to buy the kit back.
So can I just bottom that out? Supposing that that's the right approach, what evidence might you have, what propositions might you have sought to establish through evidence?
But it's not, your Lordship has this point, it's not just different evidence we might have called, it's also would the trial have been conducted differently as regards the evidence. So we might have, had the point been raised, we might have had the benefit of clearer findings of fact, that if the Commissioner's stance on what was originally issue 1 was wrong, then there was a subjective intention to reacquire. 255 doesn't quite say that, but let's assume on the side for a second. And that there were no other relevant factual circumstances that would bear on the interpretation of Section 11. Just you see, the only reason I stood up to intervene is what my learned friend was doing is saying, look, I've got a toehold on the far bank, I'll get permission. What I now need to do is to make sure that that bridgehead is broad enough so that there's an argument I can win. And my contention is if he has permission to run the argument in the way your Lordship put it, the point's not arguable. So he recognises that, so he needs to broaden it out. And what he's doing, subtly, skillfully, is to try and broaden out that bridgehead to give himself the freedom to run an argument in the Court of Appeal when we get to the full hearing that gives him a prospect of getting home. I mean, and the broader he makes it, the more I complain that the more matters.
How do you formulate his argument? What's he saying to us, according to you, that it's not subjective intention is not enough? There's a more of a package of fact that determines what purpose means for Section 11 purpose.
He says two things. One is subjective intention is not determinative, and you have to have regard to the other circumstances. And in addressing the Ramsey argument that ex-hypothesized this court has given when from permission to run, one can and should have regard to all of the relevant factors that were before the first tier that might bear on the statutory construction of Section 11.
Coming back to my Lord's point, though, in terms of evidence, the only bit you could deal with on that was the subjective intention thing. I mean, that's what's within your knowledge or your client's knowledge. And the rest of it, the analysis and objective factors are on the legal side of the line, aren't they? When you come to put it all into the jigsaw puzzle, into the pot, depending on how you want to.
Well, it depends what my learned friend later in front of this court says is a relevant circumstance. Because we were not given an opportunity to address an argument we didn't know was coming.
Well, isn't the relevant circumstance the loop about which there are findings of fact?
But this only arises in circumstances where the court has rejected the argument issue 1
on section 61, as I've understood it, and I may have misunderstood it, you then shift, you say, well, how about running those arguments? That was exactly what the UT was hinting, almost indicating, is you've picked the wrong section. You should have advanced all these arguments in relation to section 11. That's how that's
what my lady said below, in effect, yes. But that was an observation that the Commissioner should have run a different Ramsey argument by looking to some still unidentified circumstances that might bear on the construction of section 11 rather than section 61(1)(a).
So, well, I come back to, is it that complicated? Isn't it a question of, at least if you follow through the UT, looking at the loop elements, if we call them that, the artifice, the things they do make findings about, and saying, how does that play in the context of section 11? Is that something that section 11 says you would take into account when you're looking at purpose and provision, or not?
That's put that way, it's a question of law.
Yeah.
And I say the answer to that's clearly no.
Right.
Because that's not a requirement of section 11. That may be a matter for another day, but that's why I say it's just not arguable.
I hear you, and I think Mr. Davies says, but I think he thinks it is arguable, and we'll come back to him. And
It wouldn't be a surprise if we disagreed. But my observation, because I'm not helping the court any further, but if you give Maloney for permission on the basis that subjective intention was to reacquire the kit for use in the business,
that wouldn't necessarily, in all circumstances, solve the problem.
well, if it does, the point's unarguable, and if it doesn't, my clients are still exposed to the prospect that there will be something said by this court later that would have been a relevant issue we could have explored before the first tier.
Can I float with you and then I'll float with Mr. Davey? The other possibility, which you might think is not wholly attractive having spent the morning here, which is to adjourn the question of permission to the full hearing, because at that stage it should be apparent to the court exactly what really would matter.
Well, I had considered that. I came to the conclusion that that's a course that's clearly open to the court. It's not attractive because we, in effect, spent the morning having a shadow debate of one that will come in 6 months' time, and my lady having deferred the original application to this oral hearing. Carefully how I put this, but the court should really decide now so that the parties can know in advance of that appeal hearing the scope of the debate, not least for listing reasons. It's a debate about section 61, we haven't discussed this, my friend and I, but that might be a 2-day hearing, whereas if we add this point on, it might become a 3-day hearing.
I mean, you could spend 2 days on section 61, could you?
It depends whether the court is going to have any appetite for understanding the history of the Ramsey approach. I'm going to say no, it's not necessary. But you'll have seen that the first tier spent an inordinate
They spent a very, very long time swimming through various authorities.
unnecessarily.
Quite. Well, I think for what it's worth, I would agree. It's the approach is well established now, isn't it?
Yes, it's as my learned friend put it this morning. It's a purposive construction of the statute and a realistic appreciation of the facts.
It's Arrowtown and BMBF, isn't it? That's what
And
it is.
Rossendale and Hurstwood in the Supreme Court very recently. But my observation was just that this has practical consequences both for the court in terms of listing, but also for the parties in terms of costs to be incurred in preparing for an argument that I would say is unarguable if the learned friend gets permission in the formulation that your lordship currently suggests.
Mr. Davey.
I'm not sure, but I have very much to say. I would simply say that the facts have been found. The FTT has produced a long decision, including some 50 or so paragraphs of fact-finding. No one seeks to do anything with those facts in the UT. No one's seeking to do so now. We do say that the question essentially is how the facts that have been found. And to be clear, one absolutely cannot simply say, okay, the factual jigsaw puzzle comprises 100 pieces, but in the Court of Appeal we're only allowed to look at one. I mean, that would be, which I understand my learned friend to be suggesting as the way forward, that would absolutely be the antithesis of the very thing that we're told one must do if one looks at Arrowtown, BNBF, and so on and so forth. But the question is simply this: how do the facts that have been found mesh or not mesh with the contours of the statutory language? It's as simple as that. We say the court has everything it needs to deal with that point. My learned friend has been pressed on a number of occasions, what further evidence would he need? I won't repeat the answer that's been given, but I do say there's an absence. There isn't some further element. It's not that there would have been an expert report. It's not that there would have been that particular bundle of papers that were never put in the bundle. He's been pressed on it a number of times. There isn't anything that's missing. We simply say we have the facts found. There is an important point to determine. It's the very thing that this court does every day of the week. And we do say it's an arguable point, and permission should be granted. Of course, if your lordship and your ladyship consider that the better approach is to hit pause, think further, deal with it on the day of the appeal, then I'm in the court's hands. But I would suggest that there isn't enough has been put before the court this morning to make the decision, and the right decision is to exercise the discretion to allow the permission. Unless I can assist further.
I think what we'll do is go and have a word.
All rise.
Although this is only a point on permission to appeal, we're going to reserve judgment. We hope that you would get the answer fairly quickly. In the normal way, you will be provided with the judgment in draft. Hand down in accordance with what is current practice will be remote rather than in court. We'd be grateful, as I know you both know, for you to point out our typographical and similar errors, but not to try to re-argue the debate. I suppose there will be a need for an order, whatever we say, so we'd be grateful if you'd seek to agree that. If there are points on which you disagree, could you please deal with them in writing, and we'd expect to rule on them in the order that we make. And as I know you'll both be very well aware, remember the embargo, especially in the light of the Counsel General for Wales case. But for now, thank you both very much, and we'll reserve judgment.
All rise.